Franklin, the property tax guy. Today we're going to review a case I have down in the town of what is it? It's the town of Bethel. Sorry about that. The mind issue there for a second. Anyway, it's not a excessive case. Perhaps mildly excessive. It's an unequal case, and the assessor has been unbelievably uncooperative. I foiled the data a long time ago. I should have had it by May in time for the Board of Assessment review hearings. And here it is, Halloween, October 31st, 2024. Should have had it sometime in May. And so finally, about 2 hours before the hearing was to be scheduled today, I got some data. I got a comparable sales report from the assessor, and I'll show it to you. Not a single one of his comparable sales were arm's length transactions. Not a one of them, which is evidence of welcome stranger, which is what my argument is. He also provided some cost reports, which is nice, but he doesn't value properties by cost. Residential properties, 210 single family residences are usually assessed by a comparable sales. So his cost data, I can't argue with it too much, except for how he calculates the land. And the petitioner bought the land for $75,000 in 2021, and he's got the land assessed at $170,000. Now he's adding $40,000 for infrastructure, which is fine. But all the other properties don't seem to have that addition, and I'll show you the comparable land assessments, and they tend to be in the $80,000 range, not $170,000. So I'm going to review the my addendum. Okay, we have a blatant welcome stranger. The town is discriminating against newcomers. So what we have is a subdivision where they built a bunch of houses like this picture right here. It's a 2,072 square foot property on 5 acres, and there's a bunch of them that are pretty similar. None of them are arm's length transactions, and the assessor is using them all, even though they're not arm's length, as his comparable sales. The assessor is obligated to be consistent in his methodology townwide, not just in this this little neighborhood. If I'm challenging the assessor's welcome stranger per opinion of council number 60. If challenged, he or she must be prepared to show how any change brings such assessment in line with those of other properties whose assessments go unchanged. So I'm going to show you some comparable sales and comparable assessments that demonstrates that the assessor didn't do that. So that this town is at a 37% equalization, and when you're at when you're not at 100% equalization, you can't just pin purchase prices, and like I said, you have to assess in a consistent manner. You don't just make this property be at 100% and everybody else hasn't changed in years. And so it really creates a problem for the new people. They're getting abused basically because pinning the purchase prices makes the assessor's job easier, but pinning the sales prices makes his job easier. But the thing is, in this case, it's even worse than that. Not only is he violating welcome stranger, but he's also using non-arm's length sales to do so, and he doesn't have a single arm's length transaction in his comparable sales analysis. Property and subdivision have been unconstitutionally selectively assessed. To selectively assess in this manner is unconstitutional. I know people don't care about the Constitution anymore, but it is the supreme law of the land. Assessor pinned on arm's length sales price and applied equalization in reverse. So he took what he thought was, this property was recently built, and so they submitted cost figures to the code people, And then, he just extrapolated, and then he applied the equalization rate in reverse. It's illegal. What we have here is a violation of welcome stranger, exasperated by assessor only pending purchase price, but also pending non-arm's length sale. Exasperated further due to equalization only being 37%. When a town is at an equalization of 37%, it means things are in disarray, and the town is refusing to do a revaluation. I mean, it's the town's job to get this right. They're collecting money from taxpayers, and they're obligated to do this job properly, and they're not doing it properly. Having a 37% equalization puts the assessor in a bad position, and it creates situations like what it is that we have here. And again, it's an issue with the town, but the assessor does sign the roll, so it's his responsibility. He's certifying the roll, and it's not proper. And I'm suggesting these assessments are arbitrary and capricious. In fact, I don't think they could be more so. And this is why the assessor doesn't want to respond to my FOIL requests in full, because he knows those reports will embarrass him, and they'll undermine his credibility in his valuation methods. So when this happens, the burden of proof switches to the assessor. The burden of proof is normally on the taxpayer, but when it's been established that the welcome stranger has been violated, the burden of proof switches to the assessor, and he then has to demonstrate value. And it'll be interesting to see if he can do that. The house is 2,072 square feet, 5.29 acres. It's assessed fair market of $1,050,000, assessed $388,500. The land is assessed at $62,900 or $170,000, even though they paid $75,000 for it. Yeah, they paid it for August 20th, 2021. Land should be $90,227, but he's saying you're adding infrastructure at $40,000. That would bring it to $130,000. So you can say that they're $40,000 high on that, but that's not taking unequal into consideration. Based on 6.2%, so what I did is I added 6.2% for 23 and 24 to bring it to 90,227. But again, it's unequal, and if you look at the other land assessments, they're way lower. So this one's being singled out because it's new. Assessor has applied a grade of excellent when it doesn't come close to meeting the definition per New York State Assessor's Manual. I won't get into the Assessor's Manual at the moment, but excellent means it's a mansion. It's classified as an estate. It's something big and elaborate on a large lot, and this is far from it. I mean, it's just a rectangular house. I mean, just take a look at that. Does that look like a mansion to you? Okay. Okay, again, opinion of counsel, Real Property Tax Law 305. An assessor may not selectively reassess properties, such as by reassessing only those properties which recently have been conveyed or improved. However, an assessor is not precluded from revaluing any real property unless the assessor reassesses all real property. Rather, an assessor may change the assessment of a particular property, class of property or neighborhood, but if challenged, he or she must be prepared to show how any change brings such assessment in line to those of other properties whose assessments go unchanged. No revaluation has been done. Therefore, the purchase price cannot be used. And it could not have been used anyway, as county records indicate the sale as non-arm's length and unusable. Grade is good, not excellent. Request the reduction to $787,500. Assessed 290, land 90, 33,384. I might just adjust that to 140 and whatever the adjustment is there. But again, the land needs to be adjusted for unequal. This is the assessor's grandmother's house. Check it out. It's got 2 full residents and a nice barn here, and he's assessed at 189. And they're in good condition. You could rent out this house for probably $1,200 a month and have yourself a nice house and barn and you wouldn't be paying any taxes and probably go towards your mortgage. And I could sell that thing for $350 all day long. Yeah, and his inventory is just all over the place. He's taking care of his grandmother. I mean, he's a great grandson taking care of his grandmother. It's very thoughtful. Okay, and so this house that I provided, it's near his grandmother's house. I just provided it as an example. The thing is assessed at 305,100 fair market value. The assessment was 76,400 or a 206,487 fair market value. He raised it to 305,100 when he saw the thing was listed for sale for 295, but it ended up selling non-arm's length for 153. So that's a demonstration of selective assessment. You don't use list prices for assessment purposes. It's ridiculous. In New York State, Welcome Stranger approached the property tax assessments where properties are reassessed solely upon sale or transfer, potentially resulting in higher assessments for new owners, has been found to violate both state and federal equal protection clauses. New York case law, such as matter of Charles Krugman versus Board of Assessors of the Village of Atlantic Beach and Feigert versus Assessor of the Town of Bedford, underscores that selective reassessment of only recently sold properties without revaluing all properties at the same time constitutes unfair treatment. This selective reassessment policy has been deemed discriminatory because it creates desperate tax burdens between new property owners and long-term owners, lacking a rational basis and failing to maintain uniformity across properties. For assessing jurisdictions with an equalization rate of less than 100%, New York law mandates that all properties must be assessed at a uniform percentage of their market value to ensure equity. Courts require assessors to avoid piecemeal reassessments and conduct comprehensive assessments of all properties to comply with equal protection principles. And that's exactly what's going on. They're assessing piecemeal. This means that even if the equalization rate is less than 100%, selective reassessment based on recent sales alone is unconstitutional in New York. In New York, if you demonstrate that assessments are conducted in violation of Welcome Stranger doctrine, you typically do not have to independently establish the property value. Courts in New York have found that providing equal treatment through selective reassessment is often sufficient to shift the burden back to the assessor to justify the assessment. This principle is illustrated in cases like matter of Krugman versus Board of the Village of Atlantic Beach, where the court found the practice unconstitutional due to the lack of uniform treatment across properties, meaning that affected taxpayers weren't required to prove the specific market value themselves when challenging the methodology. Once an unequal assessment is established based on selective reassessment, it falls on the assessor to defend the fairness of the method to demonstrate compliance with uniform assessment standards. Request reduction to 787,500 fair market value, assessed 290, land 9277, assessed 333. So let me see if I've got any other attachments for you to show you. Assessor's manual grade, we won't get into that. Comparable sales. Okay, so this is a comparable assessment analysis, not arm's length sales. So what I establish is the subject property, the petitioner's house, is assessed at $425 a square foot. I removed the land and just took the improvements and divided the assessment by the square footage, and it comes up to $425. This property is $278. This one's $122. This one's $115. This one's $319, $267, $343, and $236. So they average $243 a square foot, whereas my client's is $425. Now, keep in mind, this doesn't adjust for condition and grade. And so, I'm going to ask the assessor for what his adjustments are for condition and grade, and we can apply them. Okay, so that's that addendum. And I got one more. That's questions. Okay, so let's go to the assessor's data. Wait a minute. comparable sales. Okay, yeah, here's one more. Oh, wait a minute. Looks like I'm missing one. Oh, here it is. Okay, so I searched the New York State Sales Web, which is a database of 5217s. 5217 is a form that's filled out when you at the closing, and where you establish if it's arm's length or not, amongst other things, sale price. These are all the sales greater than 500,000 since July 1st, 2020. And so I looked up the assessments for the top sales prices, because the petitioner's assessment is $1,050,000. So you can see they're claiming he paid $950 for it, and that's, that was not an arm's length transaction. It's a complicated situation. He had the house built, so that's actually more of a cost value than a sale value. And we don't do cost valuations in residential properties. But so here's Herd Road, sold in September 30th, 21 for $737,000. It's currently assessed at $509,500. Whereas subject property is assessed for $100,000 more than that. Then this property sold for $900,000. It's assessed for $527,000. This one was assessed for $710,000, or sold for $710,000. It's assessed for $402,200. This one sold for $815,000. It sold for $6. So this is what happens when you do a proper comparable sales analysis, where the sales are actually arm's length. So the assessor has no comparable sales analysis, and his valuation is based on comparable sales, but he has none because they're not arm's length. These are arm's length transactions, and you can see it's an unequal situation. He's at a much higher percentage of value than the others. I think it's as simple as that. This is Mike Franklin, the property tax guy.